Good morning. How are you all doing? Okay, so today is 17th of April and we will begin with our Hindu analysis. So we'll cover the most important topics that have been presented in today's newspaper. Okay, so let's begin with the first topic of the day, that is vaccine injury compensation mechanism. So India right now is looking at a vaccine injury compensation mechanism. There is a high time, actually we are in a severe need for such kind of a mechanism. Why is that? I'll talk about that also. And do we have such a thing in place? That also needs to be discussed. Okay, so we know that after COVID-19, there was a rampant immunization, vaccination practice that was ongoing. People had to get themselves vaccinated, correct? Now, what happens many a times, even though it is rare, but there are side effects. There are negative consequences and people suffer injury, some sort of an injury because of that vaccination. But how will they be taken care of? That is something that's missing in India at the moment. We do not have proper laws, proper governance practices in place that will take care of vaccine injuries. So a case came in, that was the Rachna Gangu versus Union of India. Rachna Gangu versus Union of India, an unfortunate case wherein parents actually lost young daughters to negative side effects of Covishield vaccine. So now we know when vaccination practices are ongoing, immunization is ongoing, it is no longer a personal health choice that people have to make, that whether or not you get vaccinated, it's a personal health choice. More than that, it's actually a social contract. It's a moral obligation that you have to do it for the benefit of the society. So people do that, and for the right reasons they must. But what happens that at times, even though it is rare, but at times there are implications in the body, and that can lead to severe consequences. Even they could also be fatal. But in those cases, these stories are mostly, just discarded. They are not given proper compensation. The parents are not given proper compensation, or whatever. If it is not so severe, any sort of a vaccination or any medication, these things are not properly taken care of. So that is the need of the hour. That is why a vaccination injury compensation mechanism needs to be there in place in India. So it's rare, but it is real. So they can develop consequences like anaphylaxis, thrombosis, thrombocytopenia syndrome, etc. So even though rare, but if it's something is rare, does not mean that we can simply dismiss it, right? We still have to come up with a framework. And if we talk about government's data over here, then government's own record of adverse events following immunization, they say that over 92,000 such cases have been registered after Covishield vaccination. After COVID-19 vaccination, such cases have been registered. Out of that, 89,000 were minor, but some 2,700 were serious or severe, and 1,100 also deaths. Okay, so even though it is rare, but if something is rare, that does not mean that you can dismiss it. So our governance system, our law right now is silent on these cases. But we need to take care of public health. So the doctrine, one doctrine comes into place over here. That is the doctrine of legitimate expectation. Now, these are certain statements, certain terms that can be directly asked in the prelims examination. So doctrine of legitimate expectation simply means that if I as a citizen, for example, if I as a citizen of India am complying to the state's directives, state's health directives that have been given, then I must be also expecting if something goes wrong, I will not be abandoned, right? If something goes wrong, if my body starts developing any negative consequences, if I start contracting any other disease because of that, I should be relying on the government to take care of me. I should not be abandoned in those cases. So my expectation over here will be legitimate. That is the doctrine of legitimate expectation, that if a citizen is complying with the directives given by the state, then the state cannot simply abandon that person if something goes wrong, because it is against what? Article 21, our fundamental right to life. Article 21, it also talks about right to health. Right to health. So if citizens are fulfilling a social health contract, they should not be abandoned in cases where something goes wrong. So we have to protect public health. The government has to protect public health, which is the doctrine of legitimate expectation. So the current situation in India is silent on this. So what is the situation? We have a tort law, which means that we can sue for negligence. That can happen. So basically in India at the moment, if you prove somebody's fault, that there was negligence from some side, from the side of the doctor or from the side of the manufacturer of the vaccine, and that is why you have contracted problems, if you can prove that fault, then you can sue that company. So basically it all relies on proving the fault, that it was somebody's fault, it was somebody's negligence. But is it somebody's negligence? When we are talking about side effects are not caused because of somebody's fault or negligence. They are some rare biological reactions that are happening in your body. You cannot prove somebody's fault in this, that the doctor was at fault or the manufacturer was at fault. So this is the problem with Indian law at the moment, that we do not have a no fault mechanism. We have to prove somebody's fault and negligence in these cases, which is next to impossible. So that's one. Then we can also go to the Consumer Protection Code, Consumer Protection Act of 2019. Now over here also, consumers can basically go if their rights have been violated, if they have been not taken care of, if something that was promised has not been given, they have been deceived or anything of that sort. Now when we talk about these vaccines, most of the times these vaccines were free, right? Most of the times these vaccination programs, these huge level immunization programs that are run by the state, they are free. Now when something is free, can you even be considered a consumer? Many a times you won't be considered a consumer. So these are some technical legalities also over here, that in order to approach the Consumer Protection Court and prove that something has been violated, but you were a beneficiary of a free vaccine, in that case, were you even a consumer? And again, it then lies down to the fact that you will have to prove somebody's negligence. So the whole criteria is of no fault mechanism, but in India that's lacking at the moment. And then we also have PILs. PILs can always be filed, and then the court is actually going to give directives to the center, like in this case, in the Rachna Gangu case also, the court gives directive to the center that please come up with a no fault compensation mechanism, where nobody has to prove anybody's fault or negligence. But again, they will not be taking care of all the individual matters like this. So PILs are also very restrictive in their approach. And then there is always a divide between rich and poor. So the court, while hearing to this case, it said that, when you do not have such a mechanism in place, it is actually harming the poor people more than the rich people. Because if somebody is contracting any negative implications, any disease because of the side effect of a vaccine, if that person is rich, the person can still afford his or her treatment. They can go to the private hospitals, they can go to surgeons, whatever is required, and they can get themselves treated. But the poor person cannot always do so. The rich person can still afford litigation, but the poor person cannot do so. But the social contract is also upon the poor person. If something as massive as COVID-19 is taking place, the poor person also has to get themselves vaccinated. But if something goes wrong, then who is going to take care of that person? The person will just be abandoned. So this is the issue that the court cited, that you're not having a proper law in place. It's not neutral in nature. It is actually questioning the fairness also. It's a rich versus poor divide, and this divide will be widened if you do not have such laws in place. Okay, so this is the current situation. And then the court also said that India will not be the first country to come up with such a mechanism. In fact, many developed countries already have it. So we can look at their mechanisms also, and we can adapt accordingly. Like, the US has a vaccine injury compensation program, and they have special vaccine codes also. You see how specialized the system in the US is. They have special vaccine codes also to address any challenges that have come up because of the side effects of vaccination. So no stories are being unheard over there. People are getting heard, people are getting justice. Whatever compensation is needed, people are getting that. Whatever treatment is needed, people are getting that. So basically, they're not feeling abandoned. And it is not just the question of money or rich versus poor. It is actually the question of trust. There's a bigger question of trust. that will the state take care of me if I comply to the state's orders? So coming up with a law, coming up with a universal law is definitely the need of the hour to fill this trust deficit that people have in the moment. Then UK also has a vaccine damage payment scheme wherein a one-time lump sum will also be given if the injury is severe. So other countries also have it. So India can definitely look at the framework of these countries and come up with something that is working specifically for India. So some recommendations have been given, like a vaccine injury compensation act needs to be there. Right now we don't have it. Right now every time the focus is on understanding whose fault it was or proving whose fault it was, and then we are going to take action against that person or against that company or whatever that entity is. But we need to come up with a vaccine injury compensation act wherein no fault presumptive cause table will be created. It's a no fault table. We will not prove anybody's fault. Then what will we do? So we'll come up with a vaccine injury table, which simply means that whenever we're talking about a new vaccine, whenever we are encouraging people to get themselves vaccinated, we can also come up with a vaccine table which says that within so and so days, if you contract so and so implications, so and so conditions, then we will consider that this has been a negative side effect of this vaccine only. Okay, so this is the vaccine injury table. In this case, we'll not have to prove anything again because it has been mentioned in the table that, for example, let's say within 10 days of getting yourself vaccinated, you start developing severe rashes on the body. Then we are going to assume, we are going to believe that this has been caused because of the vaccine. And in that case, we will not abandon you, right? So we need that. The act basically needs to ensure that we are not relying on proving somebody's fault or somebody's negligence. We are creating this table wherein we are simply saying we are giving certain conditions that if these conditions are fulfilled, we are going to believe that so and so thing has happened because of the consequence of the vaccine. And in that case, the person needs to be treated. If the person can be treated, then definitely medication, whatever needs to be given by the state, that should be done. If unfortunately death has happened or something of that sort has happened, in that case proper compensation needs to be given. But whatever it is, it needs to be completely heard and understood. And then we also need to have an independent administrative tribunal. For anything going wrong, for any appeals that have to be taken care of, we also need to have an independent tribunal. So this is what the article says, that the need of the hour is to come up with a vaccine compensation mechanism, a no-fault compensation mechanism. We are not taking into account anybody's fault, but we are not even abandoning the citizens of the state for simply complying with the directives that were given by the state. All right. Now let's move on to the next article for the day, that is on the Sabarimala temple entry case. So we know that right now this hearing is ongoing in the Honorable Supreme Court of India, and it all started. So right now they're actually reviewing their own judgment of 2018, wherein they had actually allowed women to enter the Sabarimala temple. Now what has happened historically is that in Sabarimala temple, women of all ages are not allowed. So women of 10 to 50 years of age are not allowed to enter the temple, because that is the age when women are menstruating and they are not considered to be legitimate to be entering the temple, because the main deity over here is Lord Ayappa. Main deity is Lord Ayappa, which is supposed to be born of Lord Shiva and Mohini, which was actually a female avatar of Lord Vishnu. And Lord Ayappa is considered to be an eternal celibate. That is why it's believed that women of menstruating age should not enter the temple, as it is not going to be considered pure for the deity or pure for the temple premises. So that happened. It was happening historically. This is a temple in Kerala, right? It's a temple in Kerala. Now, earlier what happened, that this ban was justified. This ban on women, it was actually justified. But in 2018, the Honorable Supreme Court of India gave a judgment while listening to a case that was filed by the Young Lawyers Association. So they gave a judgment by 4:1 that women should be allowed. It is against their right to equality and right of religion, right to practice any religion. So it's against all these things. They must be allowed, and no such ban should exist because it is unconstitutional. So 4:1 was the majority that was given, but then it did not sit well with a lot of people, a lot of devotees, a lot of even the center and the state and everybody. So now what is happening, that the Supreme Court is again reviewing the judgment, and all sorts of petitions are being heard from all the different experts, people who are in the favor, people who are in against. All these things are happening, and then the Supreme Court is going to come up with a final verdict. And some bigger questions are being asked over here. The center's role also becomes very important. The judiciary's role also becomes very important in this case. And there are some questions that they are trying to answer. It is no longer just about the entry of females. It's actually about some bigger questions like equality versus religion. Equality, Article 14 versus religion, Article 25, Article 26. So every citizen of India has the right to equality. We have to be treated equally in the eyes of the law. We cannot be discriminated against, right? Now, Article 25 and Article 26 also, right to practice any religion. This is for individuals, that you practice, profess, propagate any religion. And this is for Article 26 is for religious denominations. Religious denominations, that you simply you can manage your own religious affairs. State's interference is not going to be there. You can propagate your religion, you can manage your own religious affairs and everything. Now all of these are fundamental rights. So that's why the gravity of the situation is very high, that what are we trying to prove here? Which is one fundamental right actually superlative to the other, or are they in contradiction with each other? When there is a contradiction, which right is going to prevail? So these are some very big, very grave questions that the Supreme Court is trying to find answers to. And of course, no fundamental right is actually absolute. We know there are reasonable restrictions that are placed. Here also restrictions are placed on public order, health and morality, right? Which means that the center can actually decide if any law is if any practice is being considered to be violating the right to equality, then that practice can actually be struck down. So some bigger questions are being asked, that is this a discrimination, some form of an untouchability that is being practiced, that you're not allowing women of a certain age group to enter the temple? Is it a form of an untouchability, or is it a violation of their individual's fundamental rights, or is it a violation of the religious denomination's right, the Sabarimala temple's right, the Ayyappa devotees' rights? So whose rights are being violated in this case? Then what is an essential religious practice? ERP, essential religious practice. This is one of the core questions being asked. Now, there are some practices, okay, that are considered to be absolutely fundamental to any religion, that are very fundamental. If anything goes wrong, or if that practice is struck down, then the essence is going to be lost. That religion's essence, that practice's essence is going to be lost. So every religion has some essential practices, some fundamental practices, and these religious denominations can actually protect those essential religious practices, and the center or the court should not be intervening in that. It should not be interfering in that. All these religious denominations, they have their right to protect their own essential religious practices, correct? Now the question asked over here is that who is deciding this? The religious denominations are deciding it, but to what extent can they decide it? How are we going to justify, or how are we going to draw that line, that is this religious practice really essential to that faith? And if something goes wrong, if we actually, or is it or are the fundamental rights more supreme in this regard? So not allowing females to enter the temple of a particular age, so is it really an essential practice of that faith or not? This is the bigger question that is being asked. And to what extent can courts intervene and decide if something is a religious practice essential or not? Is this judicial overreach? So again, these are questions that are being asked. then who decides these religious practices, right? Religious denominations, the center, the court, who is deciding it? Center has a power that if there is a practice that is, considered to be derogatory, undignified, something that is in violation of the fundamental rights, then that practice can be struck down. But again, who has the final authority? Do courts have this authority or not? And then, are the Ayyappa devotees a separate religious denomination? Now here again we are saying, how are you defining a religious denomination? Now within a faith, within a religion, these religious denominations can exist if they have something special that they are practicing. So are Lord Ayyappa's devotees actually a religious denomination? Can we consider them to be a religious denomination? So in the previous judgment, the Supreme Court has said that no, they are not a separate religious denomination. They are well identified within Hinduism only. Their practices are similar to Hinduism. So they are not really a separate religious denomination. But then there was contention against this also. These people believe, devotees believe, that they are a separate religious denomination. They should be deciding what are their essential religious practices, and the court should not be intervening to that extent. And is this discrimination? Is this actually discrimination? Is this like Article 17? Is this like practicing untouchability? What is it? So these are some very, cliche constitutional questions that are being asked in the Supreme Court, and the court is trying to find answers to these. So the center has been saying that the court should not be intervening in these cases. Court is not an expert of religion. Court is not an expert of faith. So court should not be intervening and deciding what is going wrong. But then the court also says that court can definitely strike down laws or strike down customs or rituals which are undignified, which are basically precarious in nature. For example, like sati was there. So in different cases, the court can actually come up and say that if certain practices are undignified, if certain practices are discriminatory, they're violating the fundamental rights, they can actually be struck down. So it is not judicial overreach. This is what the court is saying. But the center feels something different is there. And it's not just about gender justice over here, because there are certain, arguments actually are very strong, both in the favor also and in against also. So in favor also, when people say that women should be allowed, so they are saying that this should be pro gender justice, and women should be allowed, they should not be discriminated, they should be given a right to practice their own faith also. They have an individual right to religion also, freedom of religion also. They should be able to practice that. And then against are also there, that there are certain temples in which males are also not allowed. There are and then there are certain practices that have to be taken care of. There is a 41-day penance that devotees actually have to practice in order to go and pay their tribute to the temple. So maybe that is going to be very physically very challenging, biologically very challenging for the females to do so. So there are very strong arguments that are there in both in both the teams. So it's up to the Honorable Supreme Court of India to decide what actually should be done, what should not be done, what should be allowed, what should not be allowed. But these are some greater questions that are being asked at the moment. Okay. And then we have the delimitation issue, the third article for today, the delimitation issue, which is being discussed very severely in the Lok Sabha. Yesterday itself, a special session started in the Lok Sabha. 3 very important bills have been tabled, and delimitation bill is one of them. Now the southern states and the northern states are actually divided on this issue, and the Women's Reservation Act has now been linked to delimitation. In fact, very recently, this act now came into force. April 16, 2026 is the day when the Women's Reservation Act has come into force. But there are 2 prerequisites that have to be solved. One, census. We need census data, and then we need delimitation. And only then this reservation is going to be implemented in the 2029 Lok Sabha. This is what is the order that has been given in the Women's Reservation Act. But the southern states are feeling that this is politically driven. They are saying, why are you tying it with delimitation? Why are you tying women's reservation with delimitation? Because delimitation is a politically driven exercise, it is going to be done based on population. And the southern states have done enough. They have practiced good governance and they have reduced their population. But they should not be punished for that. And for that only, an explanation has been given given in the Lok Sabha just today, that it's not really going to punish the southern states. Their seats are going to increase. So right now, in a house of existing 543 members, currently we have 543 members, and the proposal is to expand it to some 816 members in the Lok Sabha. So the absolute number of seats in the Lok Sabha are going to increase, and then the absolute number of seats in all the states are also going to increase. So the numbers that have been given for the southern states are, like Karnataka right now has 28 seats or 5.15% of MPs. Now after the bill is passed, after the delimitation bill is passed, Karnataka's share will become 42. So the number of seats will increase from 28 to 42. And the percentage of seats in Lok Sabha of 816 members will be 5.14%. Then Andhra Pradesh, 25 seats it has, and then it will have 38 seats. After the bill is passed, it will have 38 seats. Share will also see a slight increase, 4.60 to 4.65. Telangana, 17 seats at the moment, then it will have 26 seats, 3.13% to 3.18%. Kerala, 20 seats, then it will have 30 seats. Tamil Nadu has 39 seats, and later it will have 59 seats, 7.18% to 7.23%. So the center has been trying to explain that the number of seats is going to increase even for the southern states. They will not be punished. There is not going to be a cut in their number of seats. Then what is the contention? Now you need to understand, it is not just about the absolute increase in numbers. Absolute increase in numbers definitely is going to happen, because we are going to move from 543 to 816. So an absolute number increase will happen for all the states, northern states also and southern states also. It is going to happen. But we need to understand that delimitation is tied to population. If the population is more, then in that case, the number of MPs coming from that state, coming from that constituency, they are also going to be more. And in the northern states, the population is more. So the population gap between northern and southern states, it is very skewed. Northern states have more population. So when they will have more population, the absolute increase for them is going to be higher. And if we look at the gap in that case, the relative increase in the southern states is going to be lower in comparison to the northern states. So the absolute share definitely will increase. For example, hypothetically, if there are 25 seats that the southern states have right now, out of 100 seats, then the percentage share is 25%. And if this increases to 30 seats out of 150 seats, then this percentage is going to come down, right? From 25, somewhere around 20 or something, this percentage is going to come down. So absolute increase is happening, but the share, the overall share will not increase. We have 5 southern states, and their overall share will not increase. And in Lok Sabha, it is not just about, numbers. Numbers will decide influence. Numbers will decide power, political power. You're making policies, we're discussing policies, debates, majority, things are happening. So they're not just concerned about their absolute increase in number, they're actually concerned about the decreasing power in the Lok Sabha. And that is why the southern states are raising this concern, and they are saying that we are absolutely pro women's reservation, but please do not tie it to delimitation, because delimitation right now is tied to population. And the government has been saying that we will not implement reservation right now. We'll first carry on the delimitation exercise, and we will not also wait for the current census to complete, because the current census has just started and it is going to take a lot of time. Because if we allow that to happen, then we will not be able to implement reservation by 2029. We'll have to wait until 2034, and we don't want to wait till then. So what will we do? We'll rely on the last existing update, or the latest data that we have. The latest data is 2011 census. So based on the 2011 census, we are actually going to carry on the delimitation. Then once the delimitation is done, we'll implement women's reservation. That is what the center has been saying. But the southern states have been contesting that please don't do this. Instead, let's come up with a better solution, wherein we are not just carrying out on delimitation based on population. Governance is also taken into consideration. Let's come up with a solution where governance is also rewarded. Better governance is also rewarded. Let's discuss that framework first, and then we'll carry on the delimitation exercise. And because a lot of stakeholders are involved here, definitely delays are going to happen, procedural delays are going to happen. So let's not wait till then. You implement women's reservation right now. Amend the law of Women's Reservation Act, because the Women's Reservation Act at the moment says that first of all, census data will need to be completed, delimitation exercise will need to be completed, and only then reservation will happen. So don't tie it to delimitation. That's what they are saying. Amend that. Don't tie it to delimitation. You simply implement it right now, and we'll come up with a solution later on. But this is the exact contention. But the center has been clarifying that, you know, your number of seats are not going to decrease, your influence is going to increase, and everything of that sort. But of course, there is contention at the moment, and for that, the center and states will have to come together and they'll have to discuss what can be done so that everybody is satisfied and federalism is actually cooperative in true sense. All right, so these were some important topics from today's newspaper. Whatever else is important will be covered throughout the day on our channel. Please definitely keep visiting that. Now we look at a practice question for prelims. And before we do that, you know, we have the Studio GS Foundation live online course for you. So this is a foundation course, which means your pre and main syllabus will be covered, right? So you'll get 1250 plus hours of classes, you'll get printed class notes, you'll get live chat facility, and a complete syllabus coverage in 14 months. And all of this you'll get at 34,999 rupees. You also have 3 mediums that you can choose from: English, Hindi and English. And if you wish to avail a further discount on this, then you know you have to use a coupon code, and that is SALONI, Saloni, all in capital letters only. So hurry, the admissions are already open. You can call us at 87501 87501, or you can also download the Drishti Learning app and enroll into the course. Okay, let's look at the question. With reference to vaccine injury compensation mechanisms, consider the following statements. 1. In India, there is currently a comprehensive statutory no-fault vaccine injury compensation law. 2. Under tort law, compensation for vaccine injury requires proof of negligence or fault. 3. No-fault vaccine injury compensation programs exist in countries like the US and the UK. Which of the statements given above is or are correct? A. 1 and 3 only. B. 2 and 3 only. C. 1 and 2 only. Or D. 1, 2 and 3. So please attempt this question and provide your answers in the comment section. Thank you for watching, and if you liked the video, please do like, share and subscribe to Drishti IAS English YouTube channel.